DS. Ms. Philp is here today after failing to appear before this court on June 7th, 2023. Bond is currently set at $1,654. This is the third bench warrant. She reports no employment. Last payment made on this account was in May of 2023. Front of the court recommends that a reasonable bond be set in this matter and it be scheduled for hearing on August 16th, 2023 at 8:00 a.m. before this court.
Ms. Phelps, you're before the court charged with civil contempt of court due to your failure to appear at a prior hearing as a result of your failure to pay child support. Purpose of this hearing is to set a bond that would assure your tenants at the next hearing on August 16, 2023 at 8:00 a.m. Are you able to post a bond, ma'am?
If it's reasonable, yes.
Okay, and what do you have, or what are you able to post? Do you know?
I don't know.
Okay. Well, it is your third bench warrant, so of course, taking that into consideration, you did make payments up through the last one being in May of this year, so I'm taking all of that into consideration. What I'm going to do is I'm going to reduce your bond and set your bond in the amount of $300. If you're able to post that, you'd be able to be released. Do you have any questions?
Ulrich is here today after failing to appear
Thank you.
before this court on June 28th, 2023. For the record, that was a bench warrant hearing. Mr. Ulrich was previously before the 20th of 2023. He was given a $300 bond, which he posted and then failed to appear for the hearing. Bond is currently set at $5,027. This is the sixth bench warrant. He reports that he is employed at Icon Auto Group, which is the same employer that he provided on June 20th. Front of the court's already been advised that he does not work there. Last payment made on this account was the bond forfeiture on July 28th of 2023. Prior to that, the last payment was in January. Front of the court recommends that a reasonable bond be set in this matter and it be scheduled for hearing on August 16th, 2023 at 8:45 a.m. before this court.
Mr. Ulrich, you're before the court charged with civil contempt of court due to your failure to appear at a prior hearing as a result of your failure to pay child support. Purpose of this hearing is to set a bond that would assure your tenants at the next hearing on August 16, 2023. Was that 8:00, Mr. Chapman?
That's at 8:45.
8:45 a.m. You will get notice of that in writing. Mr. Ulrich, when you were back in court before me on June 20th, I would have informed you that the next hearing was the 28th. Why didn't you show up to that hearing?
I had left here and I went to jail and got fired from my job, and I've been in jail over in Berry County, and then I had to bond out of there, and now I have a hold over in Ione County, and with all that process going on, it got me fired. And I talked to my dad over the phone, and he said he can try and get me a job where he works at this factory over in Lake Assa.
Okay.
I
Well,
just have a lot going on because I have probation, fines and costs that I have to pay off, and then I got 4 kids at home, and then this going on, and and I have no vehicle, so my vehicle got impounded. It's just a lot going on.
yeah. Well, you have to appear in court, so.
Yes. Yep. I know.
What I'm going to do is I am going to reduce your bond in hopes that you could be released. I'm going to set your bond in the amount of $500. If you're able to post that, you'd be able to be released. I will tell you, you have to show up on the 16th. If you don't show up on the 16th, you won't get a favorable bond in the future.
Alrighty. I probably won't be able to post that anyway.
Okay.
Mr. Frazier is
free to
here
go.
today
Thank
after
you.
failing to appear before Referee Delmont on June 29th, 2023. Bond is currently set at $2,328. This is the first bench warrant. He reports that he is employed at Coast to Coast Customs. Last payment made on this account was in July of 2023. The Calhoun County Sheriff's Department is requesting transportation cost reimbursement in the amount of $139.16. Front of the court recommends that a reasonable bond be set in this matter and it be scheduled for hearing on August 16th, 2023 at 8:45 a.m. before this court.
Mr. Frazier, you're before the court charged with civil contempt of court due to your failure to appear at a prior hearing as a result of your failure to pay child support. The purpose of the hearing is to set a bond that would assure your tenants at the next hearing on August 16, 2023 at 8:45 a.m. you will get notice of that in writing. Are you able to post a bond, sir?
No, I'm not right now.
Okay. Well, the court notes that it is your first bench warrant, so I'm taking that into consideration, but you do have a sizable arrearage. But the court does note your last payment was just last month, so I'm taking all that into consideration. I am going to order that you reimburse the sheriff transportation cost of $139.16. And further, I will set your bond in the amount of $200. If you're able to post that, you'd be able to be released. Do you have any questions?
No, sir.
Mr. Burden
Okay,
is here
thank you.
today
You're free to
after
go.
failing to appear before referee Delmont on September 20th, 2022. Bond is currently set at $583. This is the first bench warrant. He reports that he is self-employed. Last payment made on this account was in September of 2022. The Calhoun County Sheriff's Department is requesting transportation cost reimbursement in the amount of $129.26. Front of the court recommends that a reasonable bond be set in this matter and it be scheduled for hearing on August 16th, 2023 at 8:45 a.m. before this court.
Mr. Burden, you're before the court charged with civil contempt of court due to your failure to appear at a prior hearing as a result of your failure to pay child support. Purpose of this hearing is to set a bond that would assure your tenants at the next hearing on August 16, 2023 at 8:45 a.m. You will get notice of that in writing. Are you able to post a bond, sir?
No, I'm not at this time.
Okay. Well, court does note it's your first bench warrant, so I'm taking that into consideration. And your arrearage is not substantial, so I'm taking all of that into consideration. I will first order that you reimburse the sheriff's transportation cost of $129.26, and then I'll set your bond in the amount of $200. If you're able to post that, you'd be able to be released. Do you have any questions?
No, I just don't have any money right now to be able to post bond, so.
Okay.
How long would I be sitting in jail for?
You'll be there until the 16th when we have your hearing.
Okay.
Okay?
Ms. Bailey is
Thank you,
here
sir.
today
You're free to
after
go.
failing to appear before referee Nets. Excuse me. On February 19th, 2021. Bond is currently set at $1,566. This is the first bench warrant. She reports no employment. There have been no payments made on this account. Front of the court recommends that a reasonable bond be set in this matter and it be scheduled for hearing on August 16th, 2023 at 8:45 a.m. before this court.
Okay. Ms. Bailey, you're before the court charged with civil contempt of court due to your failure to appear at a prior hearing as a result of your failure to pay child support. Purpose of this hearing is to set a bond that assures your attendance at the next hearing on August 16, 2023 at 8:45 a.m. You will get notice of that in writing. Are you able to post a bond, ma'am?
No, sir.
Okay. Court does note that it's your first bench warrant, so I'm taking that into consideration. But the court will take also into consideration you have not made any payments ever on this particular matter, and you do
No,
have.
I have not. I have not been able to work due to my back condition.
Okay.
I've had a surgery on my back already, and I'm having another surgery on my back plus 2 on my hip, which is keeping me from working.
Okay. Well, you're going to have to get all that medical information to the front of the court. They will take that into consideration prior to the hearing that we're having coming up. Because it is your first bench warrant, I'm going to reduce your bond. I'm going to set your bond in the amount of $300. If you're able to post that, you'd be able to be released. Do you have any questions?
No.
Court will
sir.
note the appearance of Mr. Vanderhorst on behalf of the plaintiff, Ms. Capture on behalf of defendant. This matter is before the court on the defendant's motion for contribution. Ms. Capture.
Thank you, Your Honor. Not to belabor the information that is already contained in our motion. I just wanted to emphasize the fact that child support just recently was paid for the first time. The parties have been separated since May. Plaintiff does not have any additional costs. He does not have living expenses because he doesn't have to pay rent. He isn't paying any kind of utilities. He has disposable income. He is going to be benefiting from 50% of the equity in the marital home. And so we're requesting that he be responsible for 50% of the payments until this matter can be resolved. Thank
Okay, thank you. Mr. Vanderhorst, your reply.
Thank you, Your Honor. Plaintiff has been making child support payments directly to the state of Michigan through their online payment system. Plaintiff's employer did not receive the child support documents until last week. Child support payments will be directly taken from plaintiff's check starting August 11th, 2023. Plaintiff had to facilitate this information between the front of the court to his employers, so the child support payments could be deducted from his paycheck. Besides the child support payments plaintiff has made directly to the state of Michigan, plaintiff has also made payments to the defendant for the minor child's food and clothing. Plaintiff has also made financial contributions toward the mortgage through May of 2023, payments toward the defendant's vehicle, her vehicle insurance, and her cell phone bill. He is also making payments toward the party's tax bill. It is believed that defendant has started a second job, and any income she's earning through second employment should be included in determining child support. Plaintiff is aware that the mortgage payments are caught up and the home is no longer facing foreclosure. He verified this through the bank. Plaintiff has been making child support payments and is willing to continue to make the child support payments. Child support payments, as previously stated, will be directly taken from his paycheck starting August 11th, 2023. Plaintiff is asking the court to deny the defendant's motion due to the fact that plaintiff's child support payments should be sufficient for covering defendant's care of the child and her living expenses. Thank you, Your Honor.
Okay. Mr. Vanderhorst, I take it that your client is claiming an interest in the marital residence, though?
He is, Your Honor.
Okay. How much is that payment, Ms. Capture, with taxes and insurance?
Each month it is $792.11.
Okay. Well, if he's claiming an equity in the home, then obviously he should be responsible for some of that, because otherwise the amount that she's paying is in fact contributing to his equity. What the court will do is the court will order that he contribute as well and pay 1/2 of the mortgage, taxes, and insurance on the home during the pendency of this action. When, Ms. Capture, when are those payments due? Do you know?
I believe they are due on the 1st of each month.
Okay. Well, at this point, what I'm going to do is I don't want him to end up having to catch up at this point, being delayed. I'm going to have that start effective September 1, 2023, and each month thereafter during the pendency of this case. So, Ms. Capture, you can prepare that order and submit under 7-day notice of entry. The court will end this matter on behalf of the plaintiff, Ms. Capture on behalf of defendant. This matter is before the court on the defendant's motion for temporary custody, support, parenting time, and other relief. Ms. Capture.
Thank you, Your Honor. First and foremost, I would like to state for the record that this matter is about the best interests of the minor child. There's one minor child. Her name is Tess. She's 9.5 years old, and she has a great relationship with her father. The allegations in the answer provided by plaintiff are largely hearsay and in large part have nothing to do with the best interest factors. Nothing alleged apparently was done in front of the child. Defendant is, despite the allegations and the belief that they are untrue, defendant is still willing to participate in parenting time while using SoberLink so that he can prove to the court and to Ms. Doubleday that he is not an alcoholic and does not use any kind of substance, especially when he's parenting his child. I would like to emphasize to the court that defendant is a business owner. He owns and operates his own business. He successfully does that, and he pays all of the bills for the parties. Plaintiff is currently living in the marital residence. Defendant has had to move. He is currently living in the guest house of his sister's home in Marshall, Michigan. That house has adequate space for a minor child. There's another bed in the place that he lives. Also, Tess has a great relationship with her cousins and her aunt. It's a good community. And transportation was referenced as an issue by plaintiff. However, again, defendant owns his own business. He has flexible hours, and Tess's school is near his office, and so he is able to transport her to and from school every day. So she does not need to change schools. Your Honor, both parents here have an interest in maintaining a regular schedule with their daughter. The daughter would like to spend time with her dad. 50-50 makes sense here. There's nothing alleged that states that he is incapable or has been incapable of taking care of his daughter. Again, he is more than willing to use SoberLink if that is a concern that plaintiff has, just to prove that he is not using any kind of substance. So we believe that it's in the best interest of the minor child to order 50-50 parenting time, joint legal and physical custody, and a child support order that is reflective of that parenting time. Thank you.
Thank you. Mr. Todd?
Thank you, Your Honor. Your Honor, in this particular case, the status quo for the past 4 months is that defendant has not had any overnights. He has only had 10 hours of unsupervised time. At no point did defendant ever come to the home and spend every day after April 11th with the child. Sometimes he would come home and he would watch TV with the child. It doesn't make sense to remove the child from the home that she's known, the school system she's known, and where she stayed at, in essence, her whole life, to do week on, week off with someplace she's never lived or never resided with, someone who has had no overnights in the past 4 months. In terms of the work situation, so unfortunately, our biggest concern with defendant is his continued erratic behavior in combination with his substance abuse. The idea that he would use SoberLink, certainly we're not opposed to that. However, that does not account for any of the other issues that he has. Defendant unilaterally decided it was in the best interest to put plaintiff on leave of absence. However, she's continued to stay at home and, in essence, provide work through emails and telephone calls. And she has become the primary child rearer as she was during the marriage. Plaintiff chose to put her on administrative leave. However, no one else was trained to do her job. So the insurance bills hadn't been paid, the payroll taxes hadn't been paid, and she has been the person who has been reconciling the bank account. Again, this is all in line with his continued erratic behavior, which doesn't make any sense. The allegation that she would have some type of imputed income beyond what her actual income is also does not make any sense. As it relates to the property, I could be mistaken, but I don't believe that this court has ever ordered that property be sold piecemeal prior to mediation. Additionally, my client would not have anywhere to live if that happened. So we believe that this does not make sense whatsoever. Going back to custody and parenting time, the defendant has a large history of substance abuse assessment beyond just alcohol. In September of 2022, he was hospitalized for congestive heart failure. This was due to overdosing on Adderall, combined with antidepressant medication, pre-workout supplement medication, and lastly, alcohol. The only thing that would be determined if you use SoberLink is alcohol. All those other issues would not be accounted for. The plaintiff requested he take a substance abuse assessment and attend AA. He attended 4 meetings, 2 of which, unfortunately, he came home intoxicated from. And previously at that point, he would go to the office to use alcohol and whatever drugs he was using. In May of 2023, defendant somehow injured himself, breaking a collarbone, riding the child's 4-wheeler. We don't necessarily know whether or not he was intoxicated or on drugs during this, but then he unilaterally chose to drive himself to the hospital. And then beyond that, after surgery, the bars and pins were ripped out, separated, prolonging the recovery. And we believe that this all had to do with his intoxicated behavior. We believe it's best interest of the child for defendant to have supervised parenting time. Plaintiff was the primary child rearer, cooking all the meals. Defendant would rarely come home before 7:30 p.m. We believe that defendant continues to struggle significantly with addiction and mental health issues. The defendant has numerous empty bottles in his trunk, various syringes, and we have no idea what the syringes came from, as well as taking alzapram and lisoprone. As an offer of proof, we have attached some pictures. In terms of those pictures, we are not trying to besmirch the defendant, but we believe that these point to his continued erratic behavior and erratic lifestyles. Those items that are contained within a picture plaintiff has no idea what those came from. They're not anything that she knows about. We have concerns that defendant might have some total or alternate lifestyle. Defendant has not had any overnights in the past 4 months. There is an established custodial environment with the plaintiff in the marital home, and we don't believe that there's any reason to disturb that. Additionally, we do believe that a psychological evaluation is appropriate because of defendant's substance use issues. Also, defendant previously would harp on plaintiff when she wasn't at work. Then subsequently, he is the one who put her on administrative leave so she could no longer go to work. That odd behavior cycling has continued. Defendant will go through telling plaintiff that he loves her, he wants to reconcile, and then putting her on administrative leave. And then very similarly with this particular motion, after this motion was filed, defendant sent a message on July 31st, in essence, trying to reconcile, which simply make no sense. The largest concern we have are the mental health issues and the substance abuse issues, and the fact that there's an established custodial environment with the plaintiff. We won't believe any of that should be disturbed. So we are respectfully requesting plaintiff have temporary legal and physical custody. Parties have substance abuse assessments, mutual psychological evaluations, and refer the matter to FOC for investigation. And respectfully requesting defendant receive only supervised parental time until the parties have those evaluations and assessments completed.
Okay, thank you. Ms. Capser, anything else?
Yes, thank you. Your Honor, the statements made are largely inaccurate. Defendant has exercised parenting time essentially every day. The only days he does not exercise parenting time are Tuesdays because plaintiff states that it's too late for him to come over to see the minor child. Obviously, these parties are in the midst of a divorce. They do not work together any longer. Defendant felt that it was best for the work environment that his divorcing spouse no longer be in that working environment. And so she was essentially fired. Although despite being fired, defendant still continues to pay all of the bills. Again, if defendant had a substance abuse problem, he would not be able to successfully go to work and operate and own a business. Defendant has hired a CPA and assistant to do billing. That part of his business is taken care of. Again, the statements that defendant has some kind of substance abuse is completely unfounded. Plaintiff obviously took photos of some prescription pills that were prescribed to defendant. If you look at those photos clearly, the bottles are completely full. The syringes, there's no basis as to what is being alleged about syringes. The only thing that defendant can think of is the fact that over a year ago, he was diagnosed with a B12 deficiency. And so he started taking vitamin B12, which is an injectable vitamin that has no hallucinogenic or substance related issues. Just because someone owns syringes is not indicative of them having an addiction of any kind. Again, whatever these allegations are about alcohol misuse, there's no evidence that defendant has an alcohol issue. People collect bottles of alcohol or, beer bottles and keep them for a long period of time. There's no dates on these photos. We don't know where they were taken or when they were taken, or even if they belong to defendant. We don't have a history here that establishes any kind of mental or substance abuse whatsoever. There is no psych evaluation or mental health order stating that defendant is a harmful person. Defendant did go to AA because during marriage counseling, it was requested by Miss Doubleday that he attend. He did not have a problem and therefore he did not attend. He did, however, enroll in individual counseling, which he continues to go to this day. Defendant has been diagnosed with ADHD. That is why he has some prescriptions from a licensed psychologist, but that does not mean that he has any kind of substance abuse. Again, Your Honor, this is about the best interest of the child. And even though plaintiff is alleging that defendant has had supervised visitation, that's simply not the case. Defendant's only opportunity to see his daughter, because plaintiff completely unilaterally controls the parenting time schedule, has been at his own home when he comes after work to see her, or on the weekends to see her, which he does, again, every day except for Tuesdays. Your Honor, we are not opposed to having a mutual cycle evaluation of both parties. That seems to make sense here, as both parties seem to allege certain facts about the other. It would be better just to have a clear idea of what's going on. The custodial environment is with both parents. Defendant has not in any way left his child. He continues to show up, continues to participate in every event of her life, including gymnastics, which she goes to with her cousin, which is defendant's niece from his sister. Again, these allegations are unfounded. They're all based on hearsay. And there is simply no evidence other than some pictures that have no dates and are in no way possibly linked to defendant other than by what plaintiff alleges. So again, Your Honor, we're asking for joint physical and legal custody. Defendant now has adequate housing, and we would ask that a child support order be entered responsive to that schedule.
Okay,
Thank you.
Well, what the court's going to do, the court does note that it does appear that based upon the pleadings and the arguments, that the status quo has been that the child has been with the plaintiff since April 11, 2023. So we're talking approximately 4 months. What the court's going to do is going to grant temporary custody of the minor child to the plaintiff mother in this matter. The court will allow the defendant to have standard parenting time, or at basically all times and places the parties may mutually agree. Court will set support consistent with the incomes of the parties. The courts will not, I will not order the sale of the property. It's premature at this point, as this matter is pending and proceeding, and pursuant to the agreement of the plaintiff, he said he would continue the sober link, and so the court will continue that as well. And I guess I'll ask Mr. Todd, I'll ask you to prepare the order and submit under 7-day notice of entry. Court will end this matter at 9:22 a.m. You're free to go. Have a good day. Your
Honor.
Yes.
Just as a clarification, defendant doesn't currently use SoberLink. He was offering that as something to use.
Okay, I thought. Well, the court will still order. I thought you had said that he would continue that. So.
No problem. Sorry.
Okay. Court will still order it.
And I apologize, Your Honor. I believe that there was an agreement for mutual psych evals. If that's
if you want to agree to that, that's fine. I wasn't going to order it, but if the parties agree, then that's fine. Court will note the appearance of Mr. Todd on behalf of the plaintiff, Mr. Toth on the behalf of the defendant. This matter is before the court on the defendant's motion for makeup parenting time in the summer, as well as enforcement of parenting time and sanctions. I've read the answer of Mr. Todd as well in this matter. Have you read that, Mr. Toth?
Yes, Your Honor. I did not go through the 200 attachments.
Okay. Has your client yet received his 2 weeks, or has he not received anything at this point?
No, he has, Your Honor. What we're looking for are, first of all, we have an upcoming weekend where my client has been advised. It's the weekend of August 11th. That's his alternate weekend, and he's been advised that the plaintiff will not be making the child available. We're looking for makeup for Sunday, the 2nd of July, which was, I believe it was the child's birthday, where there was an agreement that it was my client's time, but the plaintiff had the child and there was to be makeup, and that never happened. 2 Wednesdays that never occurred, June 21st and July 19th, and then the weekend of July 14th. So we have a total of 5 makeup days we're asking for, Your Honor, and then we're looking for clarification that my client does not lose his alternate weekend on August 11th. And Your Honor, my client is active duty Army Reserve stationed in Chicago. He makes it a priority to get back to the area on Wednesdays. He is here for his alternate weekends, and when he misses out, it's not only inconvenient, but it's extraordinarily frustrating. I believe, Your Honor, that there perhaps is a misunderstanding by the plaintiff as to the court's March 6th, 2023 final consent order for parenting time. The order that was entered in March makes no provision for the plaintiff to have what she's describing as vacation or extended time during the summer. In July on the 14th, there's this notion that she had this vacation or kayak trip scheduled. Well, she misscheduled it. She should not have scheduled it on my client's alternate weekend. There's nothing in the court's order that provides her that opportunity. Number two, that's the same thing applies on August 11th. Apparently there is some vacation that she's talking about, and as a consequence, my client's going to lose out. To make matters worse, she never offers to make it up. She somehow determines that I'll take his weekend, I'll take my weekend and join it together. Well, Your Honor, quite frankly, she does not have the right to do so. She may argue, and I've got in my communication with Mr. Todd, there might be some argument made somehow that the preservation clause, that any and all provisions of previous orders which are not inconsistent with the terms and conditions set forth remain in full force and effect. Your Honor, quite frankly, this was a restatement of the entire parenting time schedule. Even if there was an argument that the old order provided that she have extended time during the summer, it's absolutely in conflict with what we have here. My client gets very, very limited time with his son. And when she takes his weekend, it can go up to a month before he's going to have any contact with him on the alternate weekends. So, Your Honor, I think that as it relates to the upcoming weekend, that's his alternate weekend and he intends on exercising it. As it relates to the July 14th weekend, there was no agreement that he was abandoning his time. We wouldn't be here if that was the case. Finally, Your Honor, there's some suggestion that our family wizard, there was a communication that the time on the July 14th was going to be taken. Well, actually, that's not accurate. It wasn't until June 29th that she sent him a message that she was going to be taking the child on the July 14th weekend. A day later, my client responded and said, that's not acceptable. That's my time. And so, Your Honor, it would be one thing if there was some offer that, well, we have a plan and I'll offer you makeup, but that's not it. It's just taking his time and offering no alternative when he gets very, very limited time with his son. So, Your Honor, in regard to her, what she's calling a vacation or extended time, the order does not provide her that opportunity, and absent my client's agreement, it shouldn't happen. In regard to the makeup, Your Honor, clearly the July 14th was his weekend. And then we've got the 2 Wednesdays and the summer birthday. Thank you.
Thank you. Mr. Todd?
Your Honor, I believe from a pragmatic standpoint, we would need an evidentiary hearing to sort all this out. Again, there are over 200 pages, and my client sent me various text messages from our family wizard, in essence, denying what the defendant stated. Additionally, it's my understanding that kind of at a minimum, the parties acquiesced that Ms. Reynolds would have her 2-week vacation. Additionally, it's not accurate that the most recent order is a complete order. The most recent order does not reflect custody at all. The most recent order is actually just what the defendant's parenting time will be alone, because defendant's parenting time was in fact limited subsequently from the most recent custody order. His parenting time was stopped due to his drinking behavior around the child. And so the most recent parenting time order only relates to his parenting time that was entered in March of 23, only his parenting time. My client's parenting time was never removed at all. That order doesn't state one thing about what my client's parenting time would be. Her parenting time would remain as it always has, and her parenting time has never changed. She's always been entitled to that 2-week period. So it's not inconsistent with the prior order, because again.
Explain to me how that is, Mr. Todd. How is she entitled to the 2 weeks if it's not contained in the order?
The 2 weeks are contained in the most recent custody order. It's just a modification of parenting time that we did kind of piecemeal for him alone. Her parenting time always remained the same.
Okay. Mr. Oath, what's your thought about that? Is that,
Your Honor, that's, there's only two parties involved here. If the order outlines my client's parenting time, all of the other time by default is the plaintiff's time. And the order specifically says if it's not inconsistent, well, it's clearly inconsistent. We're talking parenting time, Your Honor. We're not talking custody. We're not talking legal custody or physical custody, parenting time. In the entire order covers parenting time. By the plaintiff trying to go back and enforce a parenting time order that somehow applies to her that's 4 years old is absurd. Number two, again, Your Honor, the order is very clear, is as long as it's not inconsistent, and it is absolutely inconsistent. My client, in essence, loses his time because of her exercising something that she claims she has a right to from a previous order. If we take this logic, Your Honor, I think what is going to end up happening is every single order we're going to have entered, if it's entitled parenting time or custody, we're going to have to go back and have a specific statement that this eliminates any provisions contained in the court's order, whether it's 2 years ago or 5 years ago or 10 years ago. This is the parenting time order, Your Honor. My client's time is identified.
okay, thank you. Mr. Todd, anything else?
Yes, Your Honor. This states order regarding parenting time, defendant shall have parenting time as follows. And it doesn't state any custody provision, and my client's parenting time never changed. So
It identifies the plaintiff's alternate holidays. How can we say that it doesn't talk about her?
Okay,
It specifically says the parties shall alternate.
okay, go ahead, Mr. Todd.
And Your Honor, so in the event, I mean, is it consistent that my client has full custody? Her parenting time is never modified. And so his parenting time was suspended, and then subsequently his parenting time was reintroduced piecemeal. My client's parenting time was never modified since 2020. So everybody understood that her parenting time would remain as it had per the prior order.
Okay. Well, what the court's going to do in this matter is the court's going to, I guess, reiterate so the parties understand, because apparently they don't, that the parenting time in this matter does take priority over other time, because she has the child vast majority of the time. His parenting time is minimal in this particular matter, so that has basically first priority as it relates to any scheduling, et cetera. I'm not going to find anything as it relates to the last, the time of the kayaking trip apparently occurred on the July 14th date, because that's already passed, other than to have makeup for that. The court is going to order that, again, that his parenting time has priority, and the plaintiff should not be scheduling things on his time, weekends or his 2 weeks or anything of that nature. As it relates to apparently the weekend of August 11th is coming up, that is his weekend. He gets his weekend. So she'll have to change her plans or do something else. Court will also order that he is entitled to 5 makeup parenting times, the 2 Wednesdays, and then the other time on the weekend. And he'll make that up at basically within the next 6 months of his choosing, but not to again occur on another, like a holiday or something of that. It has to be equal time. So if it was a weekend, he gets a weekend, but he doesn't get a weekend if it's a holiday weekend. The court will reserve on any costs or anything of that nature. And I'll ask Mr. Toth that you would prepare that order and submit under 7-day notice of entry.
I will do so, Your Honor. Thank you.
Thank you. Court will note the appearance of Mr. Robinson on behalf of the plaintiff. This matter is before the court on the plaintiff's motion for temporary custody. Mr. Robinson.
Thank you, Your Honor. I think the pleadings spell out the plaintiff's position in this regard. The guardianship is due to terminate here shortly, and we're trying to.
I think Mr. Robinson, just to clarify, I think it has. I thought you put in the pleadings that was ended on August 1.
That's what I thought, but the exchange doesn't take place till August 11th or something like that.
Okay.
And I think for the reasons stated in our petition, I think, and our complaint, it's in the child's best interest that temporary custody be given to the father. Joint legal custody is fine, but temporary custody until we can have, hopefully, an expedited friend of the court hearing. This way, the child's life will have the least interruption. And I think that's what's key here.
Okay. Ms. Heights, what's your response to the motion?
So we actually have custody of Gracie.
And how do you have that?
Well, the guardianship terminated on the 1st and she was returned to me on the 1st. She is at my boyfriend's his mom's house as right now, so she doesn't hear the court proceedings, but I have her. I also have her enrolled in school already because I didn't get these court papers until about 10 days ago. She is due to start August 17th. I added her to my insurance on August 2nd. I have been proceeding as though I will get custody because that is how everything was playing out in the 4-month transition period.
Okay, maybe you can clarify. I know in reading the petition, it sounds like the plaintiff had the child 2 to 3 times per week and then 2 to 3 weekends per month, and they allege you only had 1 weekend per month.
Yeah, that is true on some circumstances. Some months I would have 2 weekends, every other weekend. That the 2 to 3 times a week and 2 to 3 weekends didn't start until about a year ago. Other than that, his visits were very limited according to his mom and what we had discussed. So that is a more recent thing. Due to me living 3 hours away during the school year, it was very hard to make sure I got my time. However, although my time was limited, it was very quality time. I would always take my weekends off of work. That way I didn't spend my weekends at work. I spent them with her. I made sure that we had things planned to do together so we could have some one-on-one and quality time to maintain our relationship. So although my time was not it wasn't quantity, but it was quality. And we have built a very, very good relationship between me and Gracie, Johnny, who is sitting next to me, and Gracie, who is going to be her stepfather, and her brother and sister that are living with me.
Okay. So you're living 3 hours away.
That is correct. This is where my family is located. When I got pregnant at 17, I moved to Michigan to be with Tyler. And when it didn't work out, I just needed support from my own family.
Okay. Mr. Robinson, any reply?
Well, Your Honor, this motion was originally set for July 31st. And, I had an unfortunate accident and I had to go in for surgery and whatnot. But the point, I still believe, even though the child has been brought down, she's enrolled in school in Marshall, where she's been a student for many years. She has significant contacts here. She's had much more contact over the years with her father. And I best interest that custody be awarded to him.
Okay. Well, in this particular matter, we obviously have some difficult facts or circumstances to play out, and it's going to necessitate a hearing in this matter. So, but it does appear that the child has been, again, acquainted with the Marshall community. The defendant acknowledges that she did not have a majority of the time with the child. As she states, it was quality time, but not quantity time. And as a result, what the court's going to do on a temporary basis is give the parties joint legal custody on a temporary basis. The court is going to grant temporary physical custody to the plaintiff in this matter. And obviously, so the child will be living with him.
Excuse me, Your Honor.
The defendant will be awarded standard parenting time. And then we will have to reassess it after we have evidentiary hearing this matter. You had something, ma'am?
Yes, Your Honor. So she has actually been enrolled in Marshall schools for only a year or two.
Okay.
Before that, she was in Homer schools.
Okay.
And she has often said without prompting that she does not like Marshall schools and that her guidance counselor is mean to her and that she
Okay.
is very excited to.
Well, that's all stuff that we will address at a hearing in this matter, but at least on a temporary basis, the court will place her with the plaintiff, and then we'll have a chance to reassess it at the time that we have a hearing in this matter. So that will be the order, and Mr. Robinson, you can prepare that and submit under a 7-day notice of entry.
Thank you, Your Honor. Would that evidentiary hearing be before you or before the front of the court referee?
What?
It's a prejudgment.
Yeah. I'll schedule that hearing before me.
Okay.
Okay, thank you. You're free to go. The court will end this matter on behalf of the defendant. This matter is before the court on the plaintiff's objection to defendant's order. Mr. Schaefer, you've stated that it does not reflect the ruling of July 24, 2023, but you didn't specify as to how, so I'm interested, how does it not reflect the ruling?
Okay, on paragraph 3, it limits what the existing order is. There is other parenting time in the existing order. That's why I changed in my proposed order from what opposing counsel put in to reflect that it is what the previous order is. There were holidays, there were other times of parenting time that my client would have that was left out. She limited it to every other week, I believe, and so that was my objection.
Okay. Ms. Greenlee-Clark, do you have any problem with the fact that the plaintiff would be entitled to alternating holidays, et cetera?
No, absolutely not. The order specifically references to the current parenting time order, and mother's parenting time shall resume pursuant to that order. We're not limiting her parenting time under that order at all.
Okay.
It appears that that the order that Mr. Schaefer submitted specifically is trying to leave out Allegan schools or Allegan County schools specifically is what my suspicion is. And just a note for the court, I haven't heard back from Mr. Schaefer, but my client still does not have the minor child. He tried to pick up the child and Mr. Schaefer's client denied that. So I'm a little upset that she's not appearing here this morning to explain that behavior.
Okay.
Well, that's not before the court anyway, Your Honor. But if you read her paragraph 3, it says at the end of the summer, the minor child remains with the father to attend Allegan schools pursuant to the current parenting time order, and the mother's parenting time shall resume under the current order of alternating weekends and mid-week parenting time. It leaves out the holidays. So that I thought the general statement that the prior order would be reinstated would cover whatever the prior order was.
Okay. Well, what the court will do is the court will obviously modify that, but that the alternating holidays are to be included. Mr. Schaefer, did you include that in your order? I don't have it in front of me, so I don't know if you submitted an order.
Okay, my language is further ordered that subject to the filing of any motions herein, the current orders shall continue. So whatever the current orders were would continue, and that would include the holidays.
Okay. And what's the problem with that, Ms. Greenlee-Clark?
My concern is that specifically it's leaving out the Allegan County school language because in their prior motion, they've indicated that Ms. Bailey has already enrolled this minor child in a school near her. And I believe it's her intention to not comply with this order. So that's why it's in this current order. And I believe that this court, specifically at the last hearing, did indicate that the minor child would be attending Allegan schools, and that's why it's in my order. Okay. So I'm fine with taking my order and just handwriting in alternating holidays. That's fine if that's his objection.
Well, my objection is that she had other parenting time.
Okay.
You limited in your proposed order, and the judge never addressed that at all at the hearing.
What we'll do is, Ms. Greenlee-Clark, I'll have you revise your order to simply include the alternating holidays, and then we don't have any problems.
Sure. Thank you, Your Honor. I'll add the alternating holiday language and resubmit.
Okay. Thank you. Court will end this matter at 9:59 a.m. You're free to go. Have a good day. Mr. Vanderhorst, on behalf of defendant, we have three matters before the court, plaintiff's motion for parenting time, plaintiff's amended motion for parenting time, and defendant's motion to hold plaintiff in contempt in this matter. Ms. Pais, you can proceed with your motion.
Your Honor, do you want me to address all motions at the same time, or?
Yeah, address everything at once. We don't need to piecemeal it and go through.
Perfect. Your Honor, we were here back in June in regards to parenting time, and this court ordered week on, week off parenting time during the summer and reviewed or reserved the issue of school parenting time, which is why we're here today. My client is still asking that during the school year that the minor children reside with him and that mom have reasonable parenting time. During this summer, my client was working 3 jobs. He now has quit his FedEx job, so he's available every evening and night for the minor children. Mom is still working second and third shift at the Gun Lake Casino, which is an hour commute from her home, where she claims to be residing in Schoolcraft. It's our understanding that during the summer, mom has actually only spent 5 overnights with the minor child, Lauren. Lauren is repeatedly being sent off during mom's parenting time to friends in Plainwell. She's staying with an aunt. She sometimes stays with grandma. So mom is not available to be with the minor child in an overnight period like dad can. Prior to filing for divorce, mom had very little to do with these children. And dad was the primary caregiver of these children, being responsible to get them to and from school. And he has continued to do so. The kids have a home, the marital home that they reside with their dad in the Schoolcraft area where they attend school. We are asking that dad or mom be awarded reasonable parenting time during the school year until further hearing in this matter due to the fact of mom's unavailability. In response to their answer, they claim that mom was the primary caregiver of these children. My client has an alcohol charge that's been taken care of. Just so this court is aware, mom was arrested for drunk driving back in 2015. So there was alcohol issues on her side. Prior to filing this motion, mom was unavailable for about 21 weeks, where she wasn't even coming home during the evenings, spending a lot of time up in the Gun Lake Casino area with, I believe, a significant other. My client has a support system here if needed. However, like I indicated, he is available now to be with the children on a regular basis and all evenings to make sure they get to and from activities. Another thing that's happened since we filed the amended motion is mom signed the child up to participate in a soccer program in Plainwell. Again, that's an hour from where this child resides and is unreasonable. I don't know what mom's expectations are of that. In regards to the contempt motion, my client has had the minor child available, Colton available for every exchange. Even last night during the exchange, the minor child was outside. He refuses to go with his mom for parenting time. Just so this court's aware, Attorney Vanderhorst and I have agreed in the past week or so to get this family into counseling with Margaret Hunter to kind of work through a lot of these issues, but not only co-parenting counseling, but also to figure out what the underlying issues are where Colton will not have a relationship with his mother. So we're in the process of starting that as well. I do know my client called Margaret Hunter last week. My client is doing everything he can to encourage the children to go to their mother during parenting time, specifically Colton, encouraging, saying that he is their mother, she needs to go. What this court should read in our answer to the contempt is technically mom has been violating the parenting time order. So she's filed this motion with unclean hands. She has picked up the minor child during dad's parenting time without notice to dad. She sends Snapchats to the minor children indicating or telling the minor children that dad's a narcissist, he's abusive, they don't have to listen to him, and that anytime they want to be picked up by mom, even during dad's parenting time, they will. Mom has done that now probably on 2 or 3 occasions without even discussing anything with dad, and taking away dad's parenting time, especially with Lauren. Dad has been denied at least a week, I believe, of parenting time that he was supposed to have with Lauren, where mom had picked up the child and kept her. So if this court's going to find my client in contempt, I would ask that matter be set for an evidentiary hearing or added on to a trial date if needed, so this court can hear the testimony regarding the same.
Yeah, I'm not going to address the contempt today because it is disputed. We'll simply have that for a subsequent evidentiary hearing. So, Mr. Vanderhorst.
Thank you, Your Honor. Yeah, we filed an answer to this motion regarding parenting time going forward. I will note that the July order that was entered in this court specified that if the issues of custody and parenting time are not resolved at mediation, which is scheduled for our second mediation September 6th with John Brundage, Your Honor, to discuss these issues. If the order states if custody and parenting time are not resolved at mediation, then the issue can be resolved at trial. The the little bit of just a little bit of background, Your Honor, once again, that there was a hostile environment created in this house for many years by the plaintiff with alcoholism, which ultimately culminated in his arrest, and later pled to drunk driving, also with a concealed weapon in his car. It's unknown at this point whether he even have a driver's license. I believe he does. I'm not certain about that. Then he's hopefully maintaining his sobriety. But alcohol was a cloud in this family, Your Honor, for many years. A hostile environment was involved. What we're trying to do is heal this family. That is true. Leslie Paisno and myself have agreed to Margaret Hunter. I've actually talked to her myself and she's talked to, I believe, both of the clients. But I would ask that an order actually be entered today, Your Honor, requiring that counseling with her is followed. She told me that she'd like to meet with the parents at her discretion at least twice this month, and then the children and go forward. So I'd like to have an order to that effect, Your Honor, ordering that happens so it makes sure, quite frankly, that counseling does happen. I believe
that's not a problem. It looks like you have an agreement. The court will order that counseling with Margaret Hunter would proceed based upon when she can schedule that. So the parties are going to have to, again, adjust their schedules to make sure that we don't have any delays in that counseling.
Thank you, Your Honor. As far as the minor child, Lauren, has been going to my client's house as per the court order, and quite frankly, doesn't want to go back to his father's house. So we have that issue to contend with. The minor son has not come to my client's house. Once again, my client went to pick the children up. He was not presented to go with her. He's 11 years old. The daughter's 12. My client lives in Schoolcraft, just 10 minutes from the school that they go to. There's absolutely no reason whatsoever that we cannot do week to week, continuing, Your Honor, until this is finally resolved at a trial. Absolutely no reason.
Well, does your client work on either second or third shift?
She works on a third shift. She is home in the morning, but before the children even get up. But once again, Your Honor, my client lives with her mother, who only works one day a week in Schoolcraft in a 4-bedroom house. Grandma's been very involved in this family for quite some time anyway. So there is an adult there evenings when my client is working, but my client is home all day long and until about 10 o'clock at night when she goes to work. So my client is there. Actually,
Schoolcraft is where the marital home is, isn't it correct?
Pardon?
Schoolcraft is where the marital home is.
Yes, Three Rivers Schoolcraft. Yes, Your Honor.
Okay.
But my client voluntarily left that home because of the hostile environment, but she lives in Schoolcraft too.
Okay. We can dispense with any hyperbole here. Or
okay. Thank you, Your Honor.
What the court's going to do in this matter is apparently both of the parties continue to reside in the Schoolcraft area. The court's going to continue the alternating parenting time of the summer at this point to occur obviously in Schoolcraft, either at the grandmother's home or at the plaintiff's home on an alternating weekly basis. And we'll continue with the counseling and again, address the other issues either at mediation or at a subsequent trial in this matter.
Very good, Your Honor.
So, Ms. Paisno, I guess I'll ask that you would prepare the orders in this matter, submit them under a 7-day notice of entry.
All right, I can do that, Your Honor. Thank you.
Okay, thank you, Your Honor.
And if we didn't, because we're coming up on it, I don't know the old order. If we didn't have the alternating holidays, add that in as well.
Okay.
Court will note the appearance of Mr. Schaefer on behalf of the plaintiff, Ms. Sharp on behalf of the defendant. The matter is before the court on the plaintiff's motion to show cause. Mr. Schaefer.
Please, the court, Your Honor. This is a show cause that Your Honor signed on 7/19/23, and the background on this is that there's an existing order from 6/3/2016, which indicates that the child care expenses would be split evenly. And there have been numerous requests from my client to Mr. Gleason to pay his half of the child care expenses. He refuses to do so, and that is why we have filed this motion. There has been expended as of June of this year, some $5,700 is set forth in our exhibit. And thus the $2,800 half of that is owed to my client. We're asking that he be held in contempt, that he be ordered to pay that amount forthwith, and any other amount that has increased since the filing of this motion, plus cost to bring this forward, since he has refused to follow the order.
Okay, Ms. Sharp, your response.
Thank you, Your Honor. Back in January of 2022, when there was the allegations that her child care started, my client said to her from the start, please, let the FOC know so that we can calculate this and, handle it through the FOC. It wasn't until the fall of 2022 that she actually filed a motion to modify the child support. And there was a new child support order that was put into effect back in May of 2023. At that time, child care is calculated into it, which my client is paying directly and handling through that. So any childcare after if the court deems that my client does owe 50% of it, any child support or childcare after May of 2023 should not be calculated into there, since he is paying the portion requested. But I believe there was a motion filed back in August or July of 2022 regarding this issue, which the court addressed, to actually send it down to FOC for a child support review. And at that point, my clients, it followed all of the recommendations and has, paid. So his belief is the fact that she, failed to report it to the FOC. He wanted from the start for her to go through the FOC so that it could be documented that he is paying what he should be paying. So his belief is that, since the Uniform Child Support Order has gone into effect and he is paying childcare now, that, he shouldn't owe that 50% because he believes that since the order of 2016, there was numerous child support orders that went and looked at childcare. So he believes that that order from 2016 does not apply, since the court looked at childcare throughout those uniform child support orders throughout that time. And so she could have reported it to FOC back in 2022, yet she failed to do so. So my client believes that whatever he owes from here on out would be through the Uniform Child Support Order, which he'll continue to pay. Thank you.
Okay, Mr. Schaefer, your reply.
Quick response, I guess they're admitting that they haven't paid anything until May of 2023. We have set out a detailed amount, and the $5,700 is until June 3rd of 23. And he hasn't paid it, and it has not been figured in any other way. The order is still in effect. The order as set forth in our Exhibit 1 indicates that's still in effect. Nothing has been changed on. So I don't think it changes my position at all, other than they've admitted that they haven't paid this pursuant to the order.
Okay. Ms. Sharp, obviously, or Mr. Schaefer saying that there hasn't been a modification in the child care and any of those subsequent orders that you've referenced. Is that accurate?
I believe that because she didn't have childcare at the time, but I believe that if she had childcare at that point, because the court reviewed childcare in, I believe, the 2021, the parties reviewed it 2021. And there was a recommendation in 2020 that also reviewed childcare. And you can actually look in the actual Uniform Child Support Order where it states in there that she has no childcare at this time, but she will be having childcare at that point when the school starts and it's no longer virtual. But she didn't have childcare at that point. And in addition, my client has never seen a bill until this motion to show cause actually has been filed. Now, I don't know if it was shared with a previous attorney or anything like that, but my client has never seen this bill until this motion was filed. So his position is that that provision actually changed if it was being reviewed by the friend of the court and by the parties in 2020 and 2021, that provision was changed, and therefore, it would be that she needs to report it to the FOC, not that he would owe 50% of it.
Okay, well, obviously, being reviewed is not the same thing as being ordered. And it does sound like there is a dispute as to what was possibly ordered and isn't. And I don't have, obviously, all of these orders before me as of today's date. So the court's going to refer the matter to the referee for a determination as to the child care arrearage. And once we get that particular number, then the court would order the payment of that. And if in fact the defendant, I understand that that's calculated now as of the May date in the in the most recent order, but anything that would occur and be an arrearage before that May date that's included in the support calculation, that would be paid in a lump sum amount either, and if he doesn't pay it, it'd be court would award to the plaintiff either a writ of garnishment, attachment, and / or execution in this matter. So the court will refer it. Mr. Schaefer, you can put that language in an order that as it relates to the accrued arrears before May date, that again, that can be handled through the garnishment, execution, or attachment.
You're very good. I'll prepare that.
Okay. Thank you. The court will end this matter at 10:20. On behalf of the plaintiff in this matter, the court will note that this matter is before the court on the objection to the referee finding and recommendation. Mr. Bland, obviously you've again objected to that. What is your intent? I've read the recommendation. I've read as well your objection. But I guess I'm looking at is you're requesting a de novo pursuant to Michigan Court Rule 3.115 parens F in this matter. What do you seek to elicit at that de novo hearing?
Well, first of all, I should note for the record, I have ordered the transcript of Mr. Snyder's hearing. Obviously, because of the shortness of time, that's not been produced. So I don't know if the court, obviously this is the court's purview. If the court wants to wait until it has a chance to review the transcript. But really, what I'm looking for is a couple things at this point, if I may elucidate for a moment.
Yeah.
I mean, at this point, I don't think there should be any parenting time for either child. And I realize Rhea is probably, as referee Snyder said, in his opinion, is clearly in both a fragile and volatile and emotional state, which I think is true. And I think it's easy to kind of maybe take a look at it at first glance and say, well, he recommended that it go through a counselor, but I'll come back to that. I'm still having an issue, and this may be just my issue, but with the idea that I don't believe the order of April 25th, 18, which I think was maybe primarily generated by referee Fryer and countersigned by the court, has been complied with. That called for a substance abuse assessment. It called for a period of absolute sobriety. During the hearing, in fairness to Dad, I think he testified, well, I did that, but we don't have it. And I think it's critical before we move on that we at least accomplish that. Let's get a substance abuse assessment. And I think then the court can make a determination whether it wants a period of sobriety or not. Now, I am cognizant that referee Snyder said no substances in the house, but there was also testimony that at this point, Dad says he's not using very much, but then I think his sister testified that he was drinking as of November 2022. So my first point would be, have we complied with that order? I think Mr. Snyder, in kind of fairness, says, well, no, we haven't, but we're going to move on. And I think it's important.
Okay. Well, just for clarifications for any subsequent de novo, and obviously I'm going to give you a chance to get the transcript, and the court will review the transcript. Are you seeking to have simply the de novo on the review of the transcript, or what parameters would you want for that subsequent hearing?
Thank you, Judge. Thank you for redirecting me. Yes, I'd like that on the transcript. The only other thing I would ask to have a reservation, if you will, for is the testimony from the child's counselor. As of today, this is sort of a moving thing. And when we come back, if we were to have a de novo, I do not feel like we need a half day or anything like that, but maybe an hour just to hear from the counselor. But yes, a review of the transcript. Thank you, Your Honor.
Okay. Why don't we do this is the court will, when you get the transcript, provide that to the court. And then after we get the transcript, we'll set the matter for a Wednesday afternoon hearing. Probably do it at 1:30. And at that point, we'll be able to have the counselor come in. And that way as well, Mr. Williams, you would have an opportunity to testify to anything additional if you need as a result of the counselor's testimony. Okay. And anything else, Mr. Bland?
No, thank you, Your Honor.
Okay. Mr. Williams, anything else?
No, I just was going to request an adjournment on this matter because I'm waiting for police reports as well. The allegations made against me by Miss Vorva regarding my daughter, and that case has been closed, but I'm still waiting for those police reports.
Okay. Well, we can take all of that up at the at the next hearing, as soon as we get the transcript, so you get whatever reports you have. I will tell you that, the court doesn't accept police reports, so you're gonna have to have the police come in and testify if you want to present that information, okay?
Okay.
Okay, thank you. We'll conclude at 10:27 a.m. The matter is before the court on the defendant's motion for entry of order. Ms. Lyla, I haven't, you filed a response, but that came in late, so the court was not able to review that. What is your response to the motion for entry of the order?
It came in late because we had that hearing on Friday, and my response is just that we had an evidentiary hearing on Friday. This order was supposed to get us until that evidentiary hearing. There was no outcome with the evidentiary hearing. It appears it's being referred to the friend of the court for an investigation.
Okay. Well, how does that impact the order then from the prior hearing?
I would just ask that this not be set into motion, considering the evidence that I provided to the referee for the evidentiary hearing, that when you first ruled on this and said, hey, with the 7-day notice, he can see the children. I've been making every attempt to, and he will not come and get them. He just won't. At this point, the kids and I are just sitting back waiting for him to contact us.
Okay.
Well,
then that should not be a problem then if we enter the order, if he's not taking his time. So I don't see where that would, again, obstruct or to infringe upon the order if he's not complying with it.
Well, it's also come to light on Friday morning that the defendant is planning to move to Grand Rapids. When we were in court on Monday with you last week and he asked you for a quick claim deed so he could do a loan modification, he put his house on the market while we were in court and he's accepted an offer on it.
Okay. Well,
so that changes how the transportation and everything.
Well, it may change, but that's subsequent to my order. That doesn't impact my order. That was from that date. So what the court's going to do is the court is going to enter the order as submitted, and then anything subsequent in this matter will be addressed at a subsequent hearing. So we will handle it in that way, and court will end this matter at 10:30 a.m. You're free to go. Have a good day.
Oh, Your Honor, we did have one additional matter before the court today.
Okay, what is that?
Your Honor, that is defendant's motion to set aside the child support recommendation from the referee.
Let me look and see if that's.
We didn't have that, so I don't know what happened to.
I have something renoticed for the 31st at 10:30. Motion to set aside referee recommendation regarding uniform child support order.
Yep, I had submitted a renotice of hearing for the hearing on the motion to set aside the child support recommendation. But Your Honor, obviously, if the court's not ready to proceed, maybe we'll renotice it again, maybe for next Monday.
It's not so much whether the court wants to proceed. It's the fact that it's not scheduled before the court. It's been renoticed. And so what happens is you can, if you want to reschedule it, you can do it for the 21st, but you won't be able to, as I'm out of circuit next Monday, so I would not be available.
We are ready to proceed at the court's direction.
Okay, well, reschedule it because it's not scheduled today. I'm not going to take up a matter that's not scheduled for today. It's not fair to the plaintiff in this matter to proceed when she doesn't have anything before her.
Yep, Your Honor. Again, I filed a renotice of hearing for the motion to set aside the child support recommendation. It was scheduled for last Monday, and I was simply directed to send a renotice of hearing. I talked to your judicial assistant, and she gave me today's date for that hearing. So I guess got lost in translation, but the renotice of hearing was filed, Your Honor. But I would be glad to obviously reschedule it for another date.
When was that filed with the clerk's office?
That was mailed on the same day that we talked about changing it from July 31 to today, August 7.
Well, you may check with the clerk if they didn't put it on the calendar.
See, the clerk did not docket it, so we didn't have the motion. Why don't you just renotice it for the 21st? We'll take it up at that time.
That'll work, Your Honor. We'll do that.
Okay, thank you.
All right, thank you.
We'll end at 10:33. This matter is before the court on the defendant's motion to set aside the referee recommendation and order in this matter. I do note, and I'll ask you, Mr. Urban, looking at the orders in this matter, there was a hearing on July 5th, 2023, and neither of the parties appeared at that hearing. So why you're asserting error when you didn't appear at the hearing to present any testimony or proofs?
Honestly, sir, I sat in the wrong waiting room. I was in your waiting room. And I tried to let Miss Bradfield know that. However, we kind of had a moment where I had to be respectful and let her just say what she had to say and then wait to put this hearing into place.
Okay. Well, you still have to establish that there was a factual or legal error committed by the referee. You don't set forth that in your motion. So what are you claiming to be the factual or legal error?
I just wanted to object to the sole parenting and custody time. Like I wanted to establish my time as a father.
Okay.
But he also was supposed to do a paternity test, given the fact that I was trying to establish my rights as a father. I was told that because I only signed the affidavit that I don't have much rights as a father. So I'm kind of learning, you know what I'm saying, how much rights I do have and what I can do and what I can go about, the way I can go about things.
Well, if you signed an affidavit, you have all the rights as long as you pursue those in court. So you didn't need to go through and get a blood test once you've signed your acknowledgement or affidavit of parentage, but you still have to file the appropriate paperwork with the courts because those are not mutually dependent. Ms. Graber, what's your position in this matter?
Mr. Urban was getting a DNA.
You're going to have to speak up, man. We can hardly hear you.
Yes, sir. I was told by the friend of the court and our caseworker that he was requesting a DNA test because he said and believed that our child was not his. I don't know what the truth is to that. Mr. Irvin has had several chances to see his son be a father since the incident in December happened. He has seen his son of over 20 times. Since the incident in December, I have told him I have no problem with him seeing his child. Taking his child is a different story, considering we are still dealing with the domestic violence case that included our child. I do not feel safe with him taking my son quite yet. We need to establish some boundaries and some ground rules and morals before I am okay with my son leaving with him. He is
Okay.
allowed to see my son. That is completely fine.
Okay, thank you. Mr. Magnuson, could you enlighten the court and provide us with some insight in this matter?
Well, I'll try, Your Honor. I can only say that from our perspective, everything was done procedurally appropriately. Mr. Irvin did file a timely answer, and we set the matter for a hearing. And as has been indicated, that was correct. Neither party appeared at that time. So we prepared an order based on the best information we had. When we bring these cases, we're dependent upon the parties to participate and provide information, as are the referees. And that did not happen in this case to the degree that it maybe should have. But I submit there's no legal basis to set aside the judgment and the uniform support order. It sounds like what the parties are looking at is perhaps modifying same, but I'll stay out of that. I would just submit everything's been done appropriately in this case, and the order should stand.
Okay, thank you. Mr. Urban, I'll give you a last opportunity to speak if there's anything else you'd like to add.
Start by saying this much. The domestic violence is definitely a valid situation. However,
Okay, I'm not going to address the domestic violence, sir. That's
I'm not saying it's the reason why I'm bringing it up. We have a non-contact order, which means I can't have contact with Desiree Graber whatsoever. Therefore, if I was to have contact with her, I'm breaking the law, and therefore my freedom is up at stake. So this is the reason why I can't communicate with Desiree at the moment until the judge approves this. The judge have yet to approve me being able to have contact with her. I still get contacted from her from time to time. Some of the messages aren't relevant to our actual child, and the actual like situation that we're going through is more like expression and emotion of things that happen. However, understanding that I missed the hearing. However, there was some type of effort. I sat in a waiting room. I called 3 or 4 times to get into the right waiting room. By the time I did speak with Julie Radmore, but she already had went about my case. Unfortunately, I just had the wrong number as far as the meeting ID, which is why I was kind of trying to make sure I was on time today in the right courtroom so that I can, assess it properly.
Okay.
But Like the biggest thing is, it's not like I wasn't trying to show up. It's not like I didn't give the effort, nor like I didn't call and try to figure out why I couldn't get to your waiting room, which is the answer is I was supposed to be in Julie Bradfield's. So I got a paper that kind of told me that I'm thinking, because it was in your courtroom, to call you. So I called you. And unfortunately, I was supposed to call the referee, Julie Bradfield. And again, I had a very, very unprofessional moment with her. So I just chose to just be quiet at that time and to follow suit as far as creating another hearing. So maybe that can be heard.
Okay. Well, and court does note that the court has reviewed that particular finding. It does believe that there are some issues between the parties as it relates to parenting time, and those can be resolved by a subsequent motion. If you want to put some mechanism in place that would basically dictate how the two of you are going to communicate for parenting time, or simply have parenting time happen with a third party present for the exchanges, you can always do that and file that motion as well. So you have other avenue available to you, sir, to get your parenting time.
If you don't mind me asking, what type of motion did you say I have to file?
Just
I'm honestly going about it
file a motion for clarification of parenting time, and to again set in place some sort of exchanges for the child to occur at either with a third party present or something of that nature. We can then put in some parameters in place that would not violate any other orders as a result of any domestic relations issues, and you could still get your parenting time. But that doesn't go to the substance of the referee's finding in this matter. The court will note that pursuant to Michigan Court Rule 3.215 parens F, that the defendant has not set forth any basis for a review of the referee's finding in this matter. It's not established any factual or legal error in this particular case. So as a result, the court will deny the motion, but subject, sir, to you filing a subsequent motion for clarification to work out any of your parenting time issues. Okay? Do you understand that?
I do now. Unfortunately,
okay.
I got advised the wrong thing.
That's fine. File your subsequent motion, and we'll take that up and put something in place, and hopefully that will work for everybody. Court will end this matter at 10:44 a.m. You're free to go. Have a motion to set aside referee recommendation and order. The basis of your objection, you said you want the case heard by the judge, but before the court would hear that, sir, you have to establish the referee made a factual or legal error at the time of that hearing. What do you believe to be the factual or legal error made by the referee?
I have two different numbers from the referee. I have a $715 number and then an $857 number. I don't know which number to what I'm paying supposed to pay.
Okay.
To start. They had to it never got revised since 2015, and then I started a job making quite a bit less than what I was making then, so they refigured, and then I got another one in the mail about a month later saying they moved it up to $857.
I note in reviewing the support recommendation that's dated filed 6/6 in this matter, that that's just the recommendation, though. It's not the order. So hold on. You have a uniform child support order, which I think is the one that you're looking at. That is set for $857 is the support amount, sir. That's the one that was signed on June 23rd. Okay. So again, what's your objection?
So I do not have any. I don't understand how I don't have any rights. I had my rights terminated. Do I still pay child support if I can't even provide health insurance and all that?
Support is not mutually dependent upon anything happening relating to custody or parenting time. So support obligation would continue, notwithstanding anything that happens in that matter, unless your rights were actually terminated, but that would require a separate hearing. I think maybe what happens is you don't have parenting time, but your rights have not been terminated, sir.
No, my rights have been terminated. My ex-wife was successful with Hillsdale County in terminating my rights. It was wrongly accused. Hillsdale did not treat me right.
Well, I don't know anything about Hillsdale. There's nothing in your pleadings about Hillsdale, so I'm not going to speculate as to what Hillsdale did or didn't do.
They did terminate my rights, though. They terminated every right. When I was, I think it was the July 25th hearing with referee Snyder. They told me I can't legally provide healthcare insurance. Nothing like that. So that also, I don't believe I should be paying child support with children I don't have.
Okay, ma'am, can you enlighten me as to what he's speaking about? I don't see anything in our files concerning any termination of parental rights. So
Sure. Yes, sir.
Yes.
Go ahead, ma'am.
Okay. CPS had sent over all of that paperwork. Sir, back in February of this year, there was a jury trial that John had requested. The jury trial happened in February where they took jurisdiction, Hillsdale County took jurisdiction, and then there was a termination of parental rights hearing in March of this year, where it was by the judge, Judge Bianchi down here in Hillsdale County, that did go ahead and terminate both of the children, his rights to both Riley and Jake.
Okay.
So you guys should have that paperwork up there. I know it was turned in by CPS and by myself, the termination paperwork.
Well, it might have been provided to the front of the court. It doesn't mean that we have it, because the front of the court is separate from the circuit court.
Sure.
So might not necessarily have it. Okay.
Now, Your Honor, there has been now the original order set forth by Judge Miller had it where paying child support. Aaron disregarded most of his paperwork. She returned the child support money up until she met her current husband. She would give a little extra time before she met her current husband. And then after that happened, she disregarded a lot of the set orders from the first order. That's why she's testified that.
Go ahead. What I'm going to do, sir, in this matter, because you've got this other issue concerning that. Clearly, I don't know what the Hillsdale County orders provided for, so I'd have to review that to make a determination. What I'm going to do is I'm going to deny your request at this time, but you can file a motion seeking to terminate the support obligation. Make sure with your motion that you do include all of the paperwork from Hillsdale so that the court has an opportunity to review that.
I haven't received anything from Hillsdale County. They only dealt with Aaron.
Well, then you're going to have to get into Hillsdale, into that circuit court, and then you're going to have to acquire the orders from that court, because there would have been orders from that hearing. So we're going to want to see those to find out what the court ruled.
Is that something Aaron can provide? She just testified she has it.
Sir, it's your motion. You have to provide it. So you're going to have to go to Hillsdale and get that. If she wants to provide it, that's fine. But otherwise, for us to get it, you're going to have to provide it with your motion to terminate the support obligation.
Now, what if I don't know if there'll be enough time to do so. If I go to Hillsdale tomorrow and get the pay, it's going to be over the 21 days before I even receive it, before I can get you that paperwork.
What happens, you're filing a separate motion, so you can schedule that in, probably I'd say schedule it in on August 21st, as I'm not available next Monday. So you can schedule it in on the 21st and we can take it up at that time. So that's what you're going to need to do. Okay?
If I won't be able to get it within 21 days of Hillsdale, I don't think I'll be able to get it within 7 days or 20 or 14 days next week.
You can get it any time and then file your motion. I'm not saying you have to file it the 21st. I'm saying that's the next available date. You can file it 3 weeks out. It's up to you as to get those records. If you went to Hillsdale to get them, they're in the file. They can make a copy for you right then. So it'll be very easy to get them.
Okay. Oh, that'd be great. Okay. So
Okay.
what was I have to file, what was it again, Your Honor?
You're filing a motion to terminate your support obligation.
Terminate support. Okay. All right. Well, thank you.
Okay. Thank you. The court will end this matter at 10:54.
Plaintiff.
Ms. Reed, enlighten us. What's happening in your case?
The parties did come to an agreement this morning that we would like to place on the record, then preserve proofs, and I'll be submitting a judgment of divorce shortly.
Okay, go ahead. You can proceed and basically state what the settlement is, and then we'll get the affirmation from the parties.
Okay, the parties have agreed that they are going to keep the house as joint tenants, and that house will remain in both of their names. Mr. Blankenship will have exclusive use of that house until such time that the parties are either agree to sell it or that it passes to Mrs. Blankenship when Mr. Blankenship passes away, as he is suffering from an incurable illness. Mrs. Blankenship will be getting a desktop computer. She will also be receiving the Chevrolet Malibu. Mr. Blankenship will be receiving the Ford Flex. Mr. Blankenship will be allowed to use a king bed until such time Miss Blankenship provides him with a new bed. Custody, parenting time, and child support are no longer relevant as the minor child in this case turned 18 last week, and each party is waiving spousal support.
Okay. Mr. Blankenship, you've heard I'll let Ms. Reed talk to you about that. Ms. Blankenship, you've heard the settlement is placed on the record by Ms. Reed. Is that accurate?
Yes, sir.
Let me go to Ms. Blankenship first. And ma'am, in this matter, you understand that if you went to trial, you could have come up with a different result. Could have been better, could have been worse, or could have been the same. You understand that?
Yes.
Let me ask you, are you willing to enter into this agreement freely and voluntarily?
Yes.
Has anybody threatened you, coerced you, used any undue influence, pressure, or promises to get you to come to this agreement?
No.
Okay, thank you. Ms. Reed, if you would inquire of your client.
Mr. Blankenship, did you hear the agreement that I just placed on the record?
Yes, I did.
Is that your full understanding of the agreement between you and your soon-to-be ex-wife?
Yes, it is.
Are you entering in this agreement voluntarily?
Yes, I am.
Nobody's threatening you, coercing you, or pressuring you in any way to come to this agreement?
No, ma'am.
And you understand that if we did not come to an agreement, and in your case, you have a right to a trial, and that trial, the judge could have ruled more favorably, less favorable, or substantially similar to you guys' agreement?
Yes.
Okay, and you are okay with us preparing a judgment of divorce to circulate and have both of you sign?
Yes.
I have no further questions.
Okay. Ms. Reed, do you want to take proofs at this time?
Yes.
Go ahead, Ms. Reed.
Mr. Blankenship, at the time the complaint for divorce was filed, had you been a resident of the state of Michigan for at least 180 days?
Yes.
Had you been a resident of Calhoun County for at least 10 days?
Yes.
Were the allegations in the complaint true when it was filed?
Yes.
Are those allegations still true today?
Yes.
Are the allegations true that there's been a breakdown in the marriage relationship to the extent the objects of matrimony have been destroyed? There remains no reasonable likelihood they can be repaired.
Yes.
And this means that at no time can you and Miss Blankenship live together as a married couple?
Yes.
To the best of your knowledge, is Miss Blankenship pregnant?
No.
And there are no remaining minor children of your marriage?
No.
Okay, and I have no further questions.
Court will find that the testimony does establish the statutory basis. There has been a showing there's been a breakdown of the marital relationship. The court will preserve the proofs in this matter pending receipt of the approved judgment. In this matter, you're not divorced till I sign those actual paperwork, but Ms. Reed will prepare those and submit those to you for both your signatures and then submit them to the court, and we'll get them entered at that point. So best of luck to both of you. I hope everything works out for you, and the court will end this hearing at 1:34 p.m. You're free to go have a plaintiff. Then I will, in fact, inquire of Mr. Robinson. What issues, ma'am, do you believe are in dispute in your case?
Custody and child support.
Okay. Are there any property issues?
Just some belongings.
Okay, well, I better put that down then. Is there any issues concerning spousal support?
No.
Okay. Mr. Robinson, any other matters that you're aware of?
No, other than the kind of counting of the $10,000 she removed from the bank account.
Well, that would fit under property, so we've got that marked. Are you in need of discovery in this matter? Ma'am, discovery is the process whereby you acquire information from the other side, either through interrogatories, which are questions of the other side that have to be answered under oath, or request for production of documents, or depositions, or any other number of things. Do you anticipate having to have discovery?
No.
Okay, Mr. Robinson?
A brief discovery, Your Honor.
Okay. I will put down October 1 as the discovery cutoff date. So, ma'am, if you are going to engage in discovery, you'll have to do that before October 1, okay?
Okay.
And then we'll set October as the month for mediation. That's where you would meet with an attorney mediator and you would attempt to resolve all the issues that you have or any number of issues that you can get resolved. And then we'll proceed only on what is not able to be agreed upon. Ma'am, do you have any mediators that you would recommend?
No, I don't.
Okay, Mr. Robinson?
I would recommend Mr. Brundage.
Okay. Ma'am, do you have any problem with Mr. Brundage serving as a mediator?
No.
Okay. And if he's not able to, who would you recommend as an alternate, Mr. Robinson?
Lisa McNiff.
Okay. Do you have any problem with Ms. McNiff serving as an alternate?
Nope.
Okay. Court will schedule the matter for a settlement conference on November 6th, 2023 at 1:30 p.m. Parties are required to be present unless we've come to a full agreement prior to that time. Okay. I'll go to Mr. Todd first. Mr. Todd, enlighten me, what's happening?
Your Honor, we had mediation once, and we made some progress, but we did not totally resolve the case. The parties were speaking together, and we still had some outstanding discovery, which I think has been largely resolved. We did promptly schedule a second mediation session set for September 13th. So I believe at this point it may be appropriate, rather than setting this case for trial, possibly setting another settlement conference in, I guess, late September or early October.
13th. Why don't we do this? I'll set the next settlement conference for September 25th. I don't want the case to get away from us, so.
Sure.
You're good.
Mr. Brueggemann, is that all right? You don't have any conflicts with the 25th?
I do not. I'm available, and I agree with Mr. Todd's description of the status of the case.
Okay. What we'll do is we'll reset this for September 25th, 2023 at 1:30 p.m. and we'll meet just like this, unless you're able to come up with an agreement prior to that time.